Hello, and welcome to Crime in Court. My name is Heather, and this is episode 49 of the Canton Cover-Up Commonwealth versus Karen Reed. And we are on verdict watch. We are waiting for justice to happen. So, at this point in time, I wanted to share this episode with you because we are on verdict watch. Like I said, we had 4 days so far of deliberation last week. Some of them are shortened days. However, the jury seems like they might be deadlocked, but then maybe not. So I'll explain as we go along. But I wanted to bring this episode to you as we're waiting for a verdict to kind of just bring us up to speed. And then also, I have a bunch of other little random things that I put in this episode just to kind of share with you that I thought were interesting. So first, we're going to go through some material regarding whether the jury will hang itself. And then I have a couple more clips and things that I want to share and some articles and stuff to read to you. So hang in there, stay with me. I know I'm anxious and nervous about waiting for this verdict. So that's why I'm doing this episode, because otherwise I'm just sitting here like, what the heck? So on Friday, midday, it was right around lunch, the jury comes back with a note to the judge, and this is their note. Why is my mouse not working? Okay, so she's gonna read the note. They're gonna discuss it a little bit, and then we'll go from there. So here is Judge Canoni reading it says it's jury question number 3. Technically, they've only asked one question, which was something regarding whatchamacallit, the um, cert, the CERT team's report. They wanted the team that showed up on the scene, not the Canton police, but the next crime scene team that showed up was the CERT team, and that was consistent of all sorts of individuals. And we know that there were people that could have been Canton PD, even though they were supposed to recuse themselves from the investigation, but they really didn't. So there's just a bunch of reasons that this whole case doesn't make sense. But so anyways, they asked for the CERT report. It doesn't exist, and they're not able to read that, which is a big deal because aren't you supposed to report when you do a crime scene and, diagram everything? Alan Jackson brought this up many times. Like, well, why don't we know where everything was found? There was only 3 pieces of taillight that were marked on a diagram. Not, it wasn't, and it wasn't, um, it was like an aerial view that Trooper Paul did, and it wasn't like, measured out correctly like you would do in a crime scene. So, anyways, they didn't get that report because it doesn't exist, but that wasn't specifically said to them. It was just oh, well, you already have everything that you're going to get in this case, is how Judge Canoni put it. But I think it's important to note that that report doesn't exist. So the thing that they're asking for, it's not that they can't have it, it's that they can't have it because it doesn't exist. I think that's a big deal, but not to her. All right. Anyways, that was their jury question number 1. The second time that they sent a note was to let the judge, or to ask the judge if they could go home early because somebody had a bus to catch or something. So that was one of the days that they went home early. So as you can see on the screen, it says verdict clock is paused at 17 hours, 26 minutes, and 46 seconds. So, all right, here we go. Please hit that like button, and let's begin.
Commonwealth versus Karen Reed.
Okay. All right, so counsel, you're aware of our note from the jury. Dear Judge Canoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all all disputed evidence. We have been unable to reach a unanimous verdict. Signed by the foreperson.
I'm going to repeat that. They said an exhaustive look at the evidence. So let's read the question one more time.
Vote from the jury. Dear Judge Cannoni,
Listen to the language that they use.
I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence,
They're saying that they have looked over it to the point of exhaustion. They've looked at it a lot. Although it was an 8-week trial, and they've only been deliberating for 4 days at this point, but really only 17 hours. So I don't know. And somebody, I think it was the DUI guy, Larry Foreman, the DUI guy, right? Isn't it Foreman? I don't know. Larry mentioned something that Kyle Rittenhouse came back with a not guilty after like 20 something hours, like 23 hours or something like that. So there is hope that they will come to the right conclusion. We're just all anxiously awaiting for this to happen. So right now, at this point, we can pretty much either guarantee that, because there's no way 12 people are, or even 11 people would be swayed to convict her. I think it is 11 not guilty and one guilty. There's one, at least one holdout, maybe two, but I'm thinking one at this point because otherwise they wouldn't have come back and said, and we'll keep deliberating, because they do. So at this point, all right, so I'm getting ahead of myself. So here, let's read the question again. Exhaustive review of the evidence.
and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. Signed by the foreperson. So I want to hear from counsel your view on whether there has been due and thorough deliberation. So let's start with the Commonwealth.
My answer would be no, Your Honor. This simply hasn't been sufficient time yet.
And what does the defense say?
We believe that there has been sufficient.
All right, so I'll hear from both of you in more detail. Mr. Lally, I will hear you.
Your Honor, the jury received this case just earlier this week. They've had slightly shortened days, and I'm not in any way, shape, or form suggesting that they haven't conducted their due diligence in regard to their deliberative process, but I would submit that it is far, far, far too early in their deliberative process to even consider giving them any kind of Tui Rodriguez instruction or anything close to that. Furthermore, what the note doesn't really indicate affirmatively that they can't come to a conclusion. It just says that they haven't come to a conclusion through their deliberative process at this time. They're not even asking for one, is what I would say.
All right.
This is important because the language that they use is important regarding this letter and whether they are forcing a hung jury or not. So, anyways, it's important regarding the exhaustive search and whatnot, letting the judge know they've done a thorough review and we can't come to a decision. Is that them asking for a hung jury or isn't it? You decide.
Thank you. Ms. Giannetti, I'll hear you.
Your Honor, I would disagree with Mr. Lally's characterization of the note. The word exhaustive is the word I think that's operative here. They're communicating to the court that they've exhausted all manner of compromise, all manner.
He's a little difficult to hear, so I'm going to sit back a little bit. He's talking about, well, what I brought up was the fact that they used the word exhaustive, not just like, well, we've looked at things and we're not really sure. It's more of a, no, we've done a really thorough and exhaustive search, and now what? Because if they are calling for a hung jury, there is the option for the judge to read this thing called, in some states it's called an Allen charge, but in Massachusetts they call it the Tui Rodriguez charge, which we'll get to. So I just needed to preface that because if the jury comes to a hung or comes to the decision that they can't come up with a decision, then the judge is able to read this charge, this language to the jury, and then send them back in and see if somebody changes their mind. So I'll read that in a second, but that's the importance of this, the wording as to whether or not this jury is hung, because do we read the Allen charge or not? And it's up to the court to decide, meaning Judge Canoni decides whether she reads this charge or not. And I'm not exactly sure why the defense is pushing for a hung jury, because that's kind of what this is going to do. Either a hung, well, but the language is kind of favorable to them too. So we'll talk about it in a
Of
second.
persuasion,
Jim.
and they're at an impasse. This is a case where the jury has the legal instructions. They've only really asked one question, which was to try to get a report that they were not allowed to get. And I think the message has been received that the evidence is closed. They won't get anything more. They've been working essentially nonstop over the last 3 to 4 days. We're approaching a weekend. They didn't come back with this at 3 o'clock or 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is the jury should be read the Tui Rodriguez model instruction and go from there.
Okay. All right.
So they are asking the court to read this Tui Rodriguez charge. And Adam Lally, the prosecutor, is going to say he does not think that, or he has said he doesn't think that it's time yet. They still, could go through more evidence and, keep deliberating before giving this instruction.
So you all know that it is within my discretion. I decide. So a case that has been
She just has to throw that in there, like it's my power to do this or not.
it's a long case. This is our 4th day of deliberations, but Tuesday was a short afternoon, maybe 2.5 hours. Wednesday, they left early because of an appointment. Yesterday was also shortened a little bit, and this note arrived with less than 3 hours of deliberations today. So the length of the trial, the length of the deliberations, I know the case we heard from 74 witnesses. There are 657 exhibits, very
657 exhibits. Wow.
complex issues in this case. I'm not prepared to find that there have been due and thorough deliberations at this point. So I am going to send them back out. We'll bring them in and we'll do that now.
So she's just delaying having to read them this charge. So she sends them back in and she tells them, go eat lunch, clear your heads, and keep deliberating. We don't need to see her say that. The next thing that I had for you was let's read the Tui charge. So let me switch screens here. All right. So, oops, I don't have the Tui charge pulled up. Hold on one second. All right, sorry about that. Found it. All right, so when jurors cannot agree, this is what the defense is asking Judge Canoni to read back to the jury because they haven't been able to decide. However, because it's her right, she decided that it's not time to read this charge yet. So, I mean, and it does matter when you read it too. There is kind of you don't want to read it too early, which I think it kind of might have been a little too early as well, but it might just be delaying the inevitable. But let's see what happens or what this says. So, our Constitution and laws, this is what she can read back to them, remember. Our Constitution and laws provide that in a criminal case, the principal way for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking, in all cases, absolute certainty cannot be attained or expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the rest of his or her own convictions, and not merely in acquiescence in the conclusion of the other jurors. So you're not supposed to be swayed by the other jurors if um, you don't really mean it. You're not supposed to just vote one way because you're letting your fellow jurors um, take the lead or whatever. You're just going with the flow and saying I'll just vote with whatever. They want you to vote your actual beliefs and convictions. Still, in order to bring 6 or 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that the case be decided. You should consider that you have been selected in the same manner and from the same source as any future jury would be. So, any other jury would be picked in the same way. There's nothing special about this particular jury except you guys have it within you to make the answer or to come together with a verdict. There is no reason to suppose that the case will ever be submitted to 6 or 12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced on one side or the other. And I just want to point out it says 6 here, but usually 6 is like civil civil, or sometimes civil court, or maybe even like a grand jury or something. But in a criminal case, you usually have 12 jurors. So I don't know why it says 6, but this is the official Massachusetts.gov uh, page that they are language that they use. All right, so with all this in mind, it is your duty to decide this case, if you can do so, conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on one side or the other. In this criminal case, the burden of proof is on the Commonwealth to establish every part of it, every essential element, beyond a reasonable doubt. If you are left in doubt as to any essential element, the defendant is entitled to the benefit of that doubt and must be acquitted. If you have any doubt in your mind, acquit, is what this is saying. If you can't decide, this language right here is really good for the defense. I think this might be why they wanted it read, because it kind of pushes them to say, well, if you have any sort of doubt, you have to give the benefit of the doubt to the defendant. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who are for acquittal should consider whether a doubt in their own minds, is a reasonable one. If it makes no impression on the minds of other jurors who are equally honest, equally intelligent, and who have heard the same evidence with the same attention, with an equal desire to arrive at the truth, and who have taken the same oath as jurors. On the other hand, those jurors who are for conviction ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. So, whether you're for conviction or an acquittal, you need to be able to explain your reasoning, and other reasonable people have it make sense to them, is kind of what this is saying. Like, it can't just be, what am I trying to say? You can't just let them, mm, like, you can't have a weird, odd opinion and it just be like, well, it wasn't any of these things. It was like a gang that came in and did this. And like, there's no evidence for that. You can't just come up with a theory out of nowhere or whatever. It has to be based on the evidence, and the other people that saw the same trial have to come to that same conclusion with you, not just like throwing anything out there at the wall and seeing what sticks. I hope that made sense. All right, so they should ask themselves whether they should distrust the weight or adequacy of the evidence if it has failed to convince the minds of their fellow jurors. I would ask you now to return to your deliberations with these thoughts in mind. So that is what, here's the instructions for reading this, and it quote or it cites the different cases in the past. There's also an alternate version. I'm not going to read that, but um, so that is the Tui Rodriguez charge, and that is what the defense wants read to the jury, which I think does kind of benefit them, and it does kind of lean more towards a acquittal than anything based on those words. If you are left with any doubt as to any essential element, the defendant is entitled to the benefit of that doubt and must be acquitted. All right, so the next clip I wanted to share with you is it's a live with attorney Melanie Little and Mark Betterow. Mark Betterow, they're both attorneys. Melanie Little is in New York. Where is Betterow at? He's in Massachusetts, but I don't know where exactly. But he goes on the Young Jerks show, and he goes on everybody's shows lately. He's like the hot topic in all of these cases, and or on all of these channels. Everybody wants to hear what he has to say. So I'm going to play a little portion of that. We're not going to listen to all of it, but they have a good conversation about what might happen, what this whole hung jury thing entails. So let me skip ahead to this, and I know I gotta move it back. It's not ready. Okay, 127. There we go.
Karen Reed trial, and it looks like we may have a hung jury. I don't know. The judge sent them back. They're supposed to come back at 3:30. What say you, my friend? What say you, Mark?
It's certainly a higher possibility than I would have thought in the beginning, or even
We've all of us people on YouTube, content creators, have been saying we're gonna get a quick turnaround for this verdict and go home, and it's gonna be a quick, easy, not guilty. Well, that's not so. And now we're thinking it could be possible that we have to be content with the hung jury, which is not a guilty. A guilty is the worst possible. And then and there's no way that anyone's going to say that she's guilty. Not all 12 of them anyways. So let's hear what they have to say. I just think that their opinions are really they're on point, and I agree with a lot of what they say.
this morning, it's a real thing. I don't know why the judge didn't give him an Allen charge and just kind of give him a pep speech and see how they react. I mean, by not doing that, she sends them back in the same kind of yucky mood they're in, and they sit around. Nothing probably changes. Then they send another note, and then what is she going to do? Say, go home for the weekend and I'll give you the charge on Monday? I think she just created like an extra 3-hour window of nothing where she should have just given them the charge, see how they handle it. And if they come back again saying we can't figure this out, then, at that point.
Yeah.
So he's saying she should have just read the charge, which I see that side, but I also kind of see that it might have been maybe too early, but we're kind of borderlining it because, I mean, they have been in deliberations for 4 days straight. So even though there might have been some shorter days, they're still working hard and working at it. So
Yeah, it's like they didn't say the magic words, It's like they didn't say the magic words, and therefore she's not going to do this. Tui Rodriguez, I'm sure, is that what it's called? The Tui Rodriguez charge in Massachusetts, which is a little bit different than an Allen charge.
Yeah.
And I read through it earlier. I don't know if you've seen it, but
No.
I feel like she's got she gets an out here in the notes where she can say, There's a pre-Tui Rodriguez charge when the jury prematurely suggests it may be at an impasse, but the judge concludes that the jury is not yet deadlocked and that a full Tui Rodriguez charge is not yet called for. But the appeals court recommends that the judge instruct the jury using the ABA recommended language in the first two paragraphs of the alternate instruction. So she used like the buzzwords, I think, in her
Yeah, she was looking for specific words, I think, from the jury. Even though they said exhaustive, I don't know how much more you can get, how clearer you can get about it.
quote, due and thorough deliberation. The judge may not send them out again without their consent. So she did use due and thorough deliberation in her reasoning to the lawyers, right? Like, it doesn't seem to me that they've used, that they've shown due and thorough deliberation.
I don't know. They did say after exhaustive review, which
Right.
suggests they're kind of, according to them, at some kind of impasse.
Mm-hmm.
So I guess you wait for them to come back one more time. Then she's got to give them the real charge, and then after that, you're done. But I mean, you don't even know how close or not close this is. Are you dealing with one kook, or are you dealing with something that's really split at greater numbers? Obviously,
And a lot of content creators also discussed whether Judge Canoni should have asked them what the split was. And I guess in Massachusetts, I don't think you can do that, but who knows? In Massachusetts, there's a lot of things you can't do that you can do in other courts, apparently, like see the witnesses' faces. Yeah, one of the courtrooms. The reason they changed to the smaller courtroom was because the bigger courtroom that they had, there was like at least 4, 8 jurors, some 6 jurors that wouldn't be able to see the witnesses' faces. They would be staring at the back of their heads. That's how the layout was. It's so odd and bizarre, this whole case. Anyways, all right. So what else do they have to say?
the higher the split, the less likely they are to ever do anything. So
Seems to me that there's probably one person in there who's like guilty and they're digging their heels in. That's the way I'm like, there's no way 12 people can say she's guilty. I just don't believe it. There's so much reasonable doubt with regard to even the car accident even happening that I
no,
couldn't wrap my head around 11 people going the other way.
no, I don't think there's any chance of a conviction, whether it's at this trial or a retrial. But I don't think it's still literally out of the realm of possibility that they could still acquit, but it's less likely than it would have appeared earlier today. But I agree. I mean, to me, it's all about the car accident. I mean,
Hmm.
if you can't find beyond a reasonable doubt that she hit him, you could go home now, because that's
Right.
down the line, not guilty.
And that should have even been the first question on the verdict form was if you find Karen Reed to be guilty, like first, did you find that that there was a car accident or that Karen Reed, hit him with a car? And if not, if your answer is no, then bye, see ya, not guilty. But if you do, then did you think that it was intentional or not intentional? And that's basically what the jury has to come up with. But it's on the jury verdict form, it's not as clear cut and easy to understand as that.
Right. So
So,
can't she make them come in tomorrow?
I mean, you could, but how do you do that when you didn't tell them that in advance and it's summer and
Yeah,
the
it's
weekend? I
true.
mean, it's just kind of, we don't most likely, right? And
Mhm.
or they're just starting now again.
Yeah, I have it up here. They're not back yet, but they're coming.
Okay. And what time do they usually quit?
When they're talking about the time, I can stop it there. All right, so that was attorney Melanie Little. Go subscribe to her channel. She has a great channel. I've been watching the whole trial with her. She's been streaming it daily. Mark Bettero he's just a guest that hops around to different channels and he has some really great insight into the law, especially because he's a Massachusetts lawyer. So he can speak a little bit on this, or at least he has Massachusetts training in the law. All right, so we're going to go back to the day they were in court, And we got, let's see. Don't play that music. I don't know if I have a, hold on. I don't want that music playing. Where's the, here it is. All right, so they went back after lunch. They deliberated for another couple of hours. We are now at 20 hours and 21 minutes and 29 seconds with the clock paused. And the jury has another question. Oh, no, this is not a question.
You are unmuted.
Thank you, BC, sir. Court session.
All right, so I sent the note in at 3:30 like I've done each day, asking if they want to go home or continue. They indicated that they want to continue until 4:15.
So 12 noon, they were ready to call it quits and say, well, we can't come up with any kind of decision. At about 3:30, they say, nope, we're still working. So that gives us hope that they might be making some progress regarding this one or two holdouts that are preventing Karen Reed from going home a free woman.
So we will continue until 4:15. Madam Court Reporter, thank you. Okay.
So they come back at 4:15. We think, will we have a verdict yet at 4:15? We all thought, it might be possible, but we don't. At 20 hours and 53 minutes, we are sitting over the weekend. They go home for the day at 4:15 on Friday, and they're going to be back Monday morning. And it's not coming up. We're just looking at the fan. A long fan premiere. And also, it's different view of the fan. Come on, where's the... Hold on one second. All right, here we go. Those are Paul's parents. This is Mr. O'Keefe, Mrs. O'Keefe.
Closing session, please be seated.
All right. So, jurors, we all know how hard you've been working. It's been a long day. We're going to let you go home. We'll see you Monday morning at 9 o'clock. To the extent that you can, please just not think about this case this weekend. Clear your heads. We'll start fresh on Monday. So, please follow those instructions.
You guys see how Alan Jackson is like staring them down? He's like, are you guys serious about this? Like, can't we just all go home now? Can you just come to a not guilty and can we go home now?
Do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it. We'll see you Monday. Thank you.
In my opinion, I think they would be all feeling sick to their stomachs because I'm nervous about this verdict and it has, I have no skin in the game really. It doesn't affect me one way or another except, I care about the case, but other than that, I'm not going to jail. It's Karen. It's Karen's life on the line here. So, it's just so difficult a situation for anyone to be in. I would be very nervous and probably puking all day, not being able to eat. So they're doing a great job not showing that. I mean, I feel like I would be, nerves would be all over my face. But, anyways, so that they went home. We were at 20 hours and 53 minutes or whatever it was. So that is, why did it do that? Hold on. I gotta get back to where I was.
That gets nowhere, knowing they have to come back Monday anyway,
Mm-hmm.
unless they thought maybe there's a chance to wrap it up now.
All right.
Nearly 7 hours of
This next clip, it's a news clip from WCVB. It's a local station out there, ABC5. And this is, I really only want to play the very end portion of this clip, so I'm going to skip to this part here. And this is what I'm concerned about. So let's play that.
Can't agree.
Late today, I spoke with John O'Keefe's brother, Paul O'Keefe, and he tells me that he and his family were gathered at a nearby location here in Dedham today when, according to Paul O'Keefe, about 25 to 30 people showed up outside, many of them wearing pink, he said, and he says they started taking pictures and video of their family. He says the O'Keefe family felt harassed and intimidated. Deliberations resume tomorrow.
Like I'm hitting the pause button and it doesn't pause. Okay, so we've got Paul O'Keefe, brother of John O'Keefe, who is saying that he is feeling threatened now because there was a group of people that showed up where he was. So let's read this incident report because the police were called. This guy, okay, I'm sorry. He may be the family member of a victim, but that doesn't make him a saint. We don't have to like put victims on pedestals here on this channel. I don't. So, John O'Keefe, as you might be aware, has been staring down Karen the entire trial. He's been sitting in that back area. This is Paul O'Keefe, in case you were wondering who he was. This is a visual. He has been sitting in that section there, right on top of Karen and her defense table. The entire time he's been staring her down, giving her nasty looks. I swear to God, if looks could kill, she would have just like imploded at the moment every time he was looking at her because man, he gave her some looks there. And I don't know how he can sit through the same trial that we all just sat through and watched. And then he not only doesn't hear the truth as to what's going on and who actually ended the life of his brother John, but he can still sit there and be angry at Karen and yet also bring the McAlberts to sit with them on the day of closing arguments. Because if you remember, Brian Albert, Jen McCabe, Carrie Roberts, and Colin Albert were sitting in the back row behind the O'Keefes, and the only way that they would have been able to get into that courtroom and sit there was if they had an invitation from the O'Keefes. So the O'Keefes are putting their stamp of approval saying, we're with the McAlberts and we believe Karen Reed is guilty, even though there is not one piece of evidence in this whole darn trial that shows that she's guilty. So you can only be so obtuse for so long if you're a victim. And you can't just sit there in your victimhood mentality and say, well, she did it and I just know, and you can't prove me otherwise. You can't be so set into your convictions of hating someone that you're so blinded by the truth and you can't see the truth. It just makes me incredulous. I mean, I don't understand. All right. So regarding his feeling harassed. So this is a police report that was written on 6/27/24. So it was the last Thursday on June 27th, 2024 at approximately 2:45 p.m. I was dispatched to the Veterans of Foreign War Club, so the VFW hall, on a report of parties attempting to enter a private function that was taking place in the hall of the club. Other officers also responded. This is in Dedham, by the way. This is a Dedham police report from John Rinn. Upon arrival, I spoke with a female wearing a pink shirt and a baseball hat who stated that she was attempting to find a public restroom to use. I informed the woman that the Veterans of Foreign War Club is a private members only club that does not allow public access. I informed her that the function room was currently rented and only members of the function were allowed to enter. While speaking with her, a small group of people began arriving in the parking lot. This is where he feels threatened. Okay, so a woman wants to go to the bathroom. She just wants to use the bathroom. And another group of people show up and he feels threatened, even though nothing happens. Property manager Francis Curran informed officers that the group gathering were not invitees to the function and that they were also not members of the Veterans of Foreign War Club. Francis Curran then informed the group that they were not welcome on the property. The small group then got into their vehicles and left without incident. But Paul O'Keefe felt threatened. Somehow, some way, he felt threatened. And how do they know you're there? A woman shows up to go to the bathroom. A group of people come over there to probably party. And this is where he feels threatened. Okay. They left without incident. And the police were called. So, what does that tell you? What does that tell you? That their first instinct, same thing with Turtle Boy over the last weekend when Turtle Boy was walking past D&E Pizza, which was owned by Chris Albert, and Colin Albert happened to be getting out of his car and walking into D&E Pizza, and his first reaction was call the cops. That is their first reaction because the cops are in their pockets apparently, or they're in the cops' pocket, whatever. They must be paying off the cops, or they have some kind of information on them. They have, it's that code, that Brotherhood of Blue, and nobody wants to like rat on their brother in blue. But you know what? It's time to rat. It's time to rat on people like Brian Albert in the police force because they're gross people. Gross. I mean, gross in like their behavior is gross. All right, so Paul feels harassed. The other thing I wanted to bring up about Paul was that I don't know if you guys know this, but Paul has a DUI or an OUI, whatever they call it, in Massachusetts. This is an incident report from the Lakeville Police Department from October 12th, 2020. And I'm bringing this up because, there we go, that's better. I'm bringing this up because not to like shame him or harass him or anything. I'm not trying to do that. But I'm bringing it up because I find it very uh, hypocritical that John can sit there and stare down Karen like he wants to end her life with his death stares, his daggers that shoot out of his eyes at her. Um, but yet, this is part of his past. All right, so vehicle 1 was traveling south on Bedford Street. Vehicle 2, was in the northbound lane turning left into Joe's Gas, 33 Bedford Street. V2 turned left in front of V1, failing to yield right of way. This caused V1 to strike V2. So V2 didn't yield, so it was V2's problem. V2, Paul was V2. This caused V1 to strike V2 and caused V1 to veer off the roadway and crashing through the large electronical Joe's Gas business sign. Operator of V1 sustained serious injuries and was transported to Good Samaritan Hospital. That's the same hospital where John O'Keefe was pronounced no longer alive. Operator of V2 sustained no injuries. So Paul didn't have any injuries, and he's the one that caused the crash, but he caused the other guy to have injuries. And he was placed under arrest. Operator of V2 received Massachusetts Uniform Citation, whatever that is. V1 sustained heavy front end damage. V2 sustained heavy damage to the front passenger side. Both vehicles were towed from the scene by Midtown Towing. So what happened? On 10/11/2020, I, Officer Andrew Cedarquist, was assigned to uniformed patrol in fully marked Lakeville Unit 164. At approximately 16:36 hours, dispatch advised a 911 call was received reporting a two-car motor vehicle accident on Bedford Street by Joe's Gas. Officer Norcross and I responded to the scene. Sergeant Pacheco, Officer Tahi, and Captain Joyce were reported to also be responding. While responding to the scene, Officer Norcross called over the radio that he would be performing a C-spine on one entrapped operator. It would be noted Bedford Street is a public way owned and maintained by the Commonwealth of Massachusetts. At this time of day, Bedford Street experienced heavy traffic flow. So a C-spine, I'm assuming, is some kind of operation to get the driver out of the car because they might have to cut portions of the car or whatnot to get him out. Once on scene, I checked on the injured operator, later identified as Carl Prather, who was operating Massachusetts registration, whatever, ending D6. While Officer Norcross was administering care to Prather, he stated, quote, "That effer turned right in front of me." So the poor guy, this Carl Prather, just got, um, not sideswiped, but he got T-boned, I think T-boned. Or no. He was forced to T-bone the other guy, I think. I don't know. Anyways, you know what I'm saying. So once on scene, I checked on the injured operator, Prather. He was in stating he was that effort turned right in front of me. Prather appeared to be in excruciating pain and complained of neck pain and loss of feeling in his extremities. Prather's vehicle was heavy front end damage and came to rest after striking the mobile gas sign. With Officer Norcross administering care to Prather, I asked who was operating the second vehicle. A Paul O'Keefe raised his hand and stated in a slurred, confused manner, "I was." O'Keefe was operating Massachusetts registration ending 2-1, which was facing westbound on the southbound land of travel. So he was turned around. His vehicle sustained heavy front passenger side damage appearing to be totaled. I asked O'Keefe to detail what happened, to which he stated, "I was driving this way, pointing northbound, and turned into here, Joe's gas station. He just hit me." I asked O'Keefe if he was injured and needed medical attention. He stated, "No, I'm fine. I didn't get hurt." It's often the case when you have a um, sorry, my dogs were running down the stairs and it would have been really loud, so I had to pause. All right. So, I don't know what I was saying or where it was. Oh, so he didn't get hurt. He was the drunk driver, and of course he didn't get hurt. He caused the accident and he's fine. He says he's fine. But the other guy is badly injured and probably stuck in his car because we need to do a C-spine. One officer needed to. All right, so with Sergeant Pacheco, Officer Tahi, and Captain Joyce now on scene, I returned to my cruiser to report the vehicles to dispatch. At this time, Lakeville Fire arrived on scene and provided high-level care to Prather. I returned to O'Keefe and asked him to detail the events. As O'Keefe was speaking, I detected a moderate odor of an alcoholic beverage coming from his person. I was unable to detect this at first due to my face mask covering my mouth and nose. Remember, this is COVID. When I returned, my mask my mask had slid down my face, exposing my nose. While speaking with O'Keefe, I observed that he was wavering from side to side, appearing to have difficulty maintaining his balance. I also observed his eyes to be bloodshot and glassy. When O'Keefe would blink, he would open and close his eyes slowly and delayed. I asked O'Keefe where he was coming from, to which he stated in a slurred, thick tongue manner, "I came from La Barren County, club after golfing and drinking, apparently. As O'Keefe spoke, I identified the odor of alcoholic beverage was coming from his mouth. The LeBaron Hill Country Club is a gold club that has a bar and serves alcohol. I asked him if he had any alcoholic beverages while he was golfing, to which he stared at me blankly for a few moments before stating, "Yeah, I had 3," in a slurred manner. I asked him what kind of alcoholic beverage did he have, to which he stated in a slow, confused manner, "Beer." Due to the moderate odor of the alcoholic beverage, his slurred and confused speech, his bloodshot and glassy eyes, and obvious lack of balance, I asked if he would perform a few roadside assessments to determine if he was okay to drive. O'Keefe stated, "Yeah, sure," in a slurred manner. I requested O'Keefe to walk over to the side parking lot away from any debris. I had pointed to an area that was flat and clear of cracks and debris. O'Keefe appeared confused and did not move. I asked him again, to which he looked at me confused with a blank stare. O'Keefe then appeared surprised, without speaking, and started to walk over to the area. As O'Keefe was walking, he appeared to have difficulty maintaining his balance. O'Keefe also appeared to correct his imbalance by widening his stance and taking smaller steps. Yeah, because an officer's not going to realize that you're doing that. As O'Keefe walked, he would waver from side to side slightly and would roll his feet to catch himself from tripping. Wow, he was wasted. That was not 3. As we got to the area, I asked if he had any new injuries once more, or if he had any past injuries that would prevent him from conducting any balance testing. O'Keefe raised his shoulders and arms, stating, "No, I'm not hurt. I'm just fine." I asked again if he had any past surgeries or injuries, to which he stated, "Nope." I asked if he wore contacts or glasses, to which he stated, "Nope." I advised him that I would now begin instruction for the first assessment. I instructed O'Keefe to remain with his feet together and his hands down by his side while I gave the initial instructions for the horizontal gaze nystagmus test. I don't know how you say that. Some test that they perform. I then gave him instructions to follow my finger with his eyes and his eyes only, keeping his head completely still. O'Keefe appeared confused and stated that he understood. I first checked for resting nystagmus, to which none was present. I don't know what that is. Horizontal gaze nystagmus test? Through the first few passes, O'Keefe moved his head. I stopped the test once and reiterated that he was to keep his head still. I checked for equal tracking, which yielded positive results. Once equal tracking was observed, I proceeded to observe his eyes' ability to smoothly track my movements. O'Keefe was showing lack of smooth pursuit through numerous passes. I then held my hand at maximum deviation, double checking both eyes, which yielded distinct and sustained nystagmus. What is nystagmus? Where's my phone? It must mean whatever um nystagmus. Involuntary eye movement, which may cause the eye to rapidly move from side to side, up and down, or in a circle, and may slightly blur your vision. So it's an involuntary eye movement. So that's what he was looking for. O'Keefe's eyes then showed onset nystagmus prior to 45 degrees. Throughout the test, O'Keefe was swaying from side to side, slightly appearing to have difficulty remaining in a stationary position. Do you guys think he's drunk or what? I think he's wasted. For the next assessment, I began to give instructions for the one-leg stand. I began the demonstration at the starting position with both feet together and hands down by his side. I then instructed him to not begin the test before I gave instruction to do so. I demonstrated by raising my left foot, stating that he could use whichever foot he felt more comfortable with, approximately 6 inches from the ground, with his toe facing down. Furthermore, I also demonstrated the straight-legged manner and held the stance. I then instructed that when I told him to begin, that he was to look at the elevated foot and count out loud. 1,000, 2, 1,000, 3, 1,000, in that fashion, reiterating that it was a 30-second test. I asked if O'Keefe understood the instruction, to which he appeared confused and did not answer. I asked if he wished for me to give the instruction once more, to which he stated, "No, I got it," in a slurred manner. When I gave the instruction to begin the test, O'Keefe raised his right foot approximately 2 feet from the ground. O'Keefe also raised his arms in a 45-degree angle past the allotted 6 inches and hopped slightly to maintain his balance. O'Keefe then bent both legs at the knees, lowering his stance. He counted to two before hopping and counted 3 1,000 twice. O'Keefe then counted to 6 1,000 before dropping his right foot to the ground and asked, "Am I done?" I advised him that it was a 30-second test, to which he looked at me confused. While attempting the assessment, O'Keefe wavered from side to side, hopped twice, bent his knees, raised his arms above the allotted 6 inches, and was unable to hold his raised foot approximately 6 inches off the ground. I don't think I could do that for 30 seconds, let alone, just sober, let alone drunk. I instructed him once more that it was a 30-second test, advising him to continue. O'Keefe paused for a moment, appearing confused, before attempting the test once more. O'Keefe raised and lowered his foot between 1 to 2 feet, raised his arms approximately 45 degrees, shuffled his left foot to maintain his balance as he wavered from side to side, and stopped counting at 7 1,000. I concluded the assessment. It should be noted O'Keefe had a flat-soled shoe that were in good condition. So can't he just call it now and say, "Dude, you're drunk"? But I guess not. There's one last assessment he must do. For the last assessment, I began to physically demonstrate the walk and turn while giving verbal instructions. I instructed O'Keefe to stand heel to toe while I demonstrated the test. O'Keefe was unable to stand heel to toe with his feet planted at an angle and periodically raising his arms and bending his knees in an attempt to remain in the position. I remained in the heel to toe fashion properly while I waited for O'Keefe to take the proper stance. O'Keefe remained with his feet offset and angled, appearing to ignore my request to assume the starting stance. I then demonstrated 3 proper steps and advised him that I was only taking 3. However, it was in fact 9 steps. I then demonstrated the proper turn, making small, short, choppy steps, and took another 3 steps back. I reiterated that it was 9 steps forward, a series of small, short, choppy steps in the proper turn, and 9 steps back, counting out loud with his hand pressed against his sides. As I gave instruction to begin, O'Keefe took 12 steps. Not 9, but 12. O'Keefe counted 12 steps with his arms raised over 12 inches. O'Keefe took the first 6 steps heel to toe with his feet angled. While taking the first 6 steps, O'Keefe raised his arms, bent his knees while wavering from side to side. This guy is like really descriptive in his police report, and I appreciate it because it's really giving you like a mental image of what's going on here. All right, so O'Keefe then stepped offline on 7, 8, 10, and 12. So he stepped out of the line or off of the line. O'Keefe stopped the test after casually turning around. I advised him that it was 9 steps back, to which he stepped back onto the yellow line and took a series of 10 steps. O'Keefe missed heel to toe, wavered from side to side, and stepped offline multiple times. I approached O'Keefe and advised him that he was under arrest. O'Keefe was secured into properly fit double locked handcuffs because he's a big guy, so they had to do double handcuffs on him that were finger checked for tightness. I secured O'Keefe into the rear of my cruiser, where he awaited transport to the station for booking. Officer Norcross remained on scene to assist Midtown Towing with the vehicles. Officer Norcross spoke to the clerk inside of Joe's Gas. She advised him that there is possibly surveillance footage that may have captured the accident. I will have the day shift follow up in the morning to attempt to retrieve the footage. I cleared the scene and transported O'Keefe to the station for booking. Once at the station, I opened the rear cruiser door to escort O'Keefe into the station. With the rear door open, I detected a strong odor of an alcoholic beverage through my face mask, which was coming from the prisoner's compartment. I escorted O'Keefe into the booking room where he was processed in accordance to the Lakeville Police Department's policy and procedure. Sergeant Pacheco afforded O'Keefe his rights to a doctor, General Laws, Chapter 263, Section 5A, right to a telephone, General Laws, Chapter 276, Section 33A, and request to submit to a chemical test pursuant to General Laws, Chapter 90, Section 24. After being advised of the penalties for such refusal consequences, O'Keefe elected to refuse the breathalyzer and was processed as such. Sergeant Pacheco processed O'Keefe as a refusal in the Drager Alco test 9510 with Officer Trahey as a witness. What is the Drager Alco test? Oh, the breathalyzer, that's what it is. I afforded O'Keefe his Miranda rights, of which he refused to speak. O'Keefe was afforded a phone bill and contacted family. Sergeant Pacheco placed O'Keefe into cell 3, where he awaited the arrival of bail. Speaking of which, Karen Reed paid his bail to get out of prison for this. So I just want to point out the irony here and the hypocrisy here. Karen Reed helped Paul O'Keefe when he did this. Financially, she helped him. She supported him and helped him through this. And Paul O'Keefe has completely turned on Karen Reed. Clerk Magistrate Fregault was notified and set bail at $540. While waiting for bail, I contacted the Lakeville Fire Department and spoke with paramedic Pam Garant in regards to the victim's status. Medic Garant advised me that he was transported to Good Samaritan Trauma Center with internal chest trauma, head trauma, neck trauma, and trauma to his collarbone. Oof, that's bad. Dispatcher Anthony Keeney advised me that the 911 call was from O'Keefe's vehicle, which reported his speed at 25 miles per hour. O'Keefe was later bailed by Clerk Magistrate Fregault. O'Keefe was issued Massachusetts uniform citation in his property bag and charged with the following: an OUI, operating under influence, liquor, and serious bodily injury, and negligence, operating to danger, and the failing to yield the right of way. And I'm only bringing this up because of the irony and the hypocrisy in which Paul O'Keefe can sit there and stare down Karen Reed as if she, you know, sacrifices babies every night. Like he really, I get it, and I empathize. I empathize with the family, empathize for what they're going for. I don't like the people that they hang around, and it shows me that if they're going to willingly hang out or invite the McAlberts and hang out with them, call them to come sit with you for closing arguments, to make a statement, it really makes me question any of their um, cognitive abilities. If they seriously sat there through that trial, listened to all the evidence and testimony, and still think Karen did it, the whole family is very evidently against Karen, and it's awful. It's awful how they're treating her. They used to like her. Like we heard from Aaron and Paul O'Keefe, and they said nothing but nice things about her on the stand. So it's just really bizarre. We were all expecting them to say these horrible things about her, but she got along with the family. She was nice. She went to church all the time with Mr. O'Keefe. And it's reported that he really likes her. He was on the defense's witness list. I'm sad that they didn't get to call him because I would have liked to have known what he was going to say. But, the defense only put on a couple expert witnesses and that was it. And lucky the plow driver. All right, so that was, oh, hold on, my dog needs sorry, had to get the dog all, comfy in her blanket. She's very needy. All right, so the next thing that I wanted to bring to your attention, and like I said, this is just like a mishmash of a bunch of different things. So there's no really like specific topic. I'm just kind of going with whatever I thought was kind of interesting that's been going on this past weekend. So the next clip I want to show you is some anti-Reed protesters that showed up on Friday at the courthouse. Um, as you have probably seen, probably aware, there's like thousands of people protesting out there now. Used to be just, I mean, it was still a big crowd before, but now it's like thousands of people are showing up because of this trial and how much it's affected people. And because the people are tired and they're sick of it. They're sick of our governments trying to run us over and take advantage of us. So, anyways, as you know, there have been plenty of people out there supporting Karen for many, many weeks. Even before the trial began, at all of her pre-trial hearings, she had crowds and crowds of people. So this Friday, there were some anti-Reed protesters that showed up just to be obnoxious, just to be, contrary, just to be contrarian. That's the word I'm looking for. So here is that clip. The fake townie blog, they just said these are people that hate Turtle Boy. That's all it is. It's people that hate Turtle Boy. They don't really think Karen is guilty. They just hate Turtle Boy. And so they have to come into Karen Reed's trial and be these obnoxious brats while um just to like make a point that like we don't like you, Aiden Carney. And this woman right here who's hiding her face in the blue shirt, that is the woman who had fake charges against him to get him arrested so that he did 60 days in prison or in jail. And yeah, she made up some she was colluding with Brian Tully, who was the boss of both Buchanan and Proctor. She was colluding with Tully and the prosecutor in Aiden's case in trying to get him to come into the apartment so that she could like make up some BS about him where there were no cameras.
Part of the state PR campaign led by Karen Reed's defense. Jessica was shot at. They are all complicit in witness intimidation. The Massachusetts State Police have had to do their job.
I think it's hilarious that they walk through and like no one's even around listening to them. They're just, I mean, obviously there are people taping it, but it's just ridiculous. Really ridiculous.
Folks, let's stick to the telephone pole, please. To the telephone pole. Thank you. Let's stick to that. Keep that going. Appreciate it. Thank you, guys.
That's Lindsay, right? It's Lindsay right there, hiding her face. See her? Being a coward and hiding her face.
This is all my fault. Could I have hit him? Did I hit him? She hit him. Every time it's done at 5 a.m. Second, when did she kill him? Wake up. I thought I could have flipped him. I didn't think I did it that hard. That's what she said. I'm leaving it ready. That's a practice. That's my word. Because she thought, no, what did you say?
What do these five think that they're proving? I don't know. There's thousands of people there for Karen, and these five are just standing there saying, I hit him, I hit him, I hit him.
No, police are square line. What is your emergency?
Yes, I need.
Why did that end?
Lies and the Logan reporter, the fake county boss, who is also a part of the state.
Thank you, guys.
Yeah, this is so stupid. They're whatever. People took pictures and they made the news. Okay, whatever. And it's so stupid because I'm going to show you this some more photos from the crowd. So this, you can see Rita. This is my thumbnail. There's so many people there for Karen. These are all the Karen supporters, and there's many, many more. This was just one small picture from the day. There's Karen walking in and out of court. There's the dummies that think Karen did it, which obviously they don't have any common sense or logic or reason. And then here's all the Karen supporters going, what the F are you five up to? Taking pictures of them. Here is a picture of, these are all Boston Globe images, by the way. So this is Karen coming into court. She finally, they've given her an escort. Before it had been the supporters escorting her in because they felt like she was not safe coming into court. So they helped escort her in, and they have been this whole trial, and now all of a sudden they can't, and it's they've got police blocking everything off. It's ridiculous. And then people are just like tailgating out of their car, the backs of their cars, and hanging out to support Karen. They're listening to the trial out on loudspeakers and things like that. So they are all, I mean, look at the ages, and there's kids that come here, people bring their dogs, younger, older. There's a child there. I mean, it's so many people have been affected by this case. It really is. I like this. Bitches unite. And it's a beautiful day for an acquittal. And I don't know who that is. A gaggle of media photographs Karen Reed as she walks out of court. Oh, okay. She's in there somewhere, but I can't tell. More people supporting Karen and Karen as she leaves the courthouse on Friday. So I don't really know what to make of these dumb protesters. They are obviously, it's Kate Peters, who Turtle Boy has a restraining order against, and because she's been harassing and stalking him. So there's that. I mean, these people are obsessively obsessed with Turtle Boy, and it has nothing to do with Karen Reed. It's because Turtle Boy has a stance on Karen Reed, and that's why they are there. And I don't like it very much, but whatever. It is what it is. And they have a right to be there just as much as everybody else. But I just think it's funny that, it's just the five of them, and pretty much nobody's paying attention to them in the clip. I think it's funny. All right, so the next thing that I wanted to bring to you guys was Criminality recently posted the enhanced 911 calls from both Carrie Roberts and Jennifer McCabe. I'm going to listen to the Carrie Roberts one first, and then we'll go into the Jennifer McCabe one. So these are enhanced, so you can hear them really clearly. They play them in the courtroom long ago. This was like probably week 1 or 2 that they played these, but you couldn't really hear it. It was bad audio. So this is finally, I found like a really good enhanced version, and here we go.
Can't please sound good.
Hi, my name is Carrie. I'm calling because my friend's boyfriend did not come home last night. They were at Waterfall, and now she is calling me hysterical because she doesn't know where he is. You didn't pick anybody up by the name of John O'Keefe, did you?
John O'Keefe?
Yeah, he's a Boston cop, and it would be on foot, but
No.
I think he probably got a ride.
So this is Carrie Roberts calling 911 before she arrived to go pick up John, I'm sorry, to go pick up Karen to go look for John, I think. It's somewhere in that morning where she calls. It's 5 in the or approximately 5 something in the morning. So yeah, this would be before she arrives to um to John's house at One Meadows, but also after Karen called her and said, "Where's John? He's missing."
And pass out at someone's house. I don't know, but
Yeah, but no, we didn't lock anybody up or anything like that. And where does he live?
he lives on Meadow, right after Pleasant.
He lives on Meadow off of Pleasant. Okay, and is the wife home? You said his girlfriend?
It's his girlfriend. Yeah, they were out having drinks, and then she left and expected him to come home at some point, and he never did.
Yep.
And so I said to her, you know, my husband had been out with him earlier in the night, but then he came home, and he has custody of his niece and nephew because their parents passed away.
Okay.
And so she's home with the niece and nephew, and they're old enough to be home. It's just she's nervous because he never even called the niece.
Yeah.
So she's like, I feel like something happened, and I said, okay. Well, so he called the area hospitals, and nobody happened. I personally think someone probably picked him up and he passed out. I don't know.
Yeah.
I don't know.
He didn't drive last night?
No.
No. Okay. I mean, yeah. I mean, again, it's more. It would be driven by you. She would have to, call in, come to the station, and talk to us. But I mean, as of right now, it's more. He just didn't come home last night. Is this common sometimes?
Exactly.
Happen with him?
No. That's why.
Yeah.
Since he didn't call his niece. That's kind of why she's more freaking out. So I figured I called the area hospitals. I said I would call Canton police just to make sure he didn't get picked up. But like I said, he's a Boston police officer. He knows a bunch of people. Anybody could have picked him up.
Yeah.
Sleeping it off.
Okay.
Apparently they were having a blizzard party of some sort.
Yeah. No.
I don't know.
They were having a blizzard party, she says, laughing, joking.
Unfortunately, I wasn't there. I was stuck here. But we didn't get any calls, anything like that. Nobody was arrested or anything like that.
Okay.
All righty.
All right. Well, thank you.
All right. No problem.
Remember, Sergeant Good was on call to answer all the 911 calls, all the emergency calls. There was no dispatcher. So there would be an officer assigned to dispatch. And Sergeant Good, who was one of the individuals who actually arrived on scene and was part of the Canton Police Department that did the original initial search, he was the one that took the call from Carrie and from Jennifer McCabe, who we're going to listen to in just a second here.
Problem. Good luck.
Okay.
See ya.
Thank you. Bye-bye.
All right, so now Jennifer McCabe's call.
No, police is square line. What is your emergency?
Yes, I need someone to come to 34 feet.
That didn't sound like Sergeant Good. There must have been another officer answering in his place at that time.
No, police is square line. What is your emergency?
Oh, Norwood.
Yes, I need to.
That's why. Her 911 call somehow got connected to Norwood Police, and she's trying to call Canton.
Someone to come to 34 Fairview Road in Canton, Mass. There's a man passed out in the snow.
You're in Canton? Hold on. I'm transferring the Canton police. You're connected to Norwood, okay?
Yeah, I don't know why I did that.
It's at the tower. So stay on the line.
I think he's dead. You got to get here.
I think he's dead. You need to get here ASAP, okay?
ASAP, okay?
I'm going to transfer the line. I'm going to transfer to Canton.
Okay. I know I am.
You can hear Karen Reed screaming in the background. I'm going to start it over again.
Yes, I need someone to come to 34 Fairview Road in Canton, Mass. There's a man passed out in the snow.
You're in Canton? Hold on. I'm transferring the Canton police. You're connected to Norwood, okay?
Yeah, I don't know why I did that.
It's at the tower. So stay on the line.
I think he's dead. You got to get here ASAP, okay?
I'm going to transfer the line. I'm going to transfer to Canton.
Okay. I know I am. Where are the blankets? I don't see blankets, Harry.
911. What's your emergency?
Yes, I need someone to come immediately to 34 Fairview Road, Canton, Mass.
What's going on?
There's a guy unresponsive in the snow.
In the snow at 34?
He passed out, yes. 34, the Albert resident. Yes, I just pulled up and found him.
Okay.
The Albert residence, she just said. The Albert residence.
34 Fairview?
34 Fairview, Canton, Mass, yes.
911.
So then why? And she clearly said it was 34 Fairview, but all the police reports, remember, said it was 32 Fairview. They put the wrong address in purposefully, even though she said it's the Albert's home, and she said 34 Fairview.
Where's your emergency? Hello?
Yes, I'm sorry. Can you come to 34 Fairview Road in Canton?
34 Fairview?
Yes, there's a man unresponsive in the snow.
Okay. Is he flew at all?
You've got to get here, okay?
Okay. What's going on? Is he face down?
We just flipped him over.
Okay.
We just flipped him over. There was nothing about him being flipped over in any reports or the way he was found. Nothing describing, like, other than face up. He was found face up. But they just said that they flipped him over. There's nothing like that in any police report anywhere.
And who's that in the background? Is that someone related?
Okay, that's his girlfriend. His name is John Keith.
Okay, how old is he?
John is 46 years old.
46. How long has he been outside?
I don't know. I don't know. He got out of the car and
Is he breathing?
He got out of the car, and this right there makes me believe Jennifer McCabe saw him get out of the car.
How old is he?
John is 46 years old.
46. How long has he been outside?
I don't know. I don't know. He got out of the car and
Is he breathing?
a couple of hours. Carrie?
Her guess is a couple of hours. A couple of hours. Not, since midnight. A couple of hours.
I don't know if he's breathing. There are two women trying to do his body heat, and they're hysterical.
Okay, can you just try to ask him? I know it's tough, but we already have the fire department going. I just got to know if he's breathing.
Is he breathing, you guys? It doesn't seem to be breathing.
Okay, do they know how to do CPR? Do they want to attempt CPR?
You guys, Carrie, can you guys do CPR? No, I guess he's gone.
Okay, they don't feel comfortable doing so?
No, I think he's passed away.
Okay. All right, we have the fire department and the police department on the way. If everyone's declining.
Jen already knows he's gone. She knows because she was there that night. She knows. She's part of the cover-up. She knows he's not coming back.
CPR, then I'll hang up with you, and if anything changes, you can give us a call back. Where are you guys outside?
Right out front of his car. I know, I'm on the phone with the ambulance. I know, honey, I know. So, Carrie, you got to get off him, honey. Carrie, you got to get off of him. This is a scene.
Do you know if there was any alcohol or drugs involved?
They had been out.
They've been out drinking?
Yes, but I'm talking hours ago, maybe. And I think I don't know how long he's been in the snow.
Okay. Is there any bleeding or anything? Maybe hit his head out?
Yes, possibly. There seems to be bleeding in the face.
Okay, bleeding from the face. All right.
Yes.
And how big the pool of blood is, if there is any?
Something's coming out of his nose, and one of the women is doing CPR.
Okay.
How big is the pool of blood? Oh, wait. We don't know because nobody went in the house and saw a pool of blood where it would have happened, where this incident happened. Probably in the basement. But nobody investigated. Nobody went inside the Albert home. So that blood that guy's asking about, it's somewhere. It's not under John, but it's somewhere on their property.
Okay, one of them is doing CPR?
Yes, they're both working on him.
All right, if she's doing CPR, just give us a call back if he becomes responsible, right? But we're on the way.
Okay, thank you.
All right. So now we have a much clearer picture of that 911 call. We always had played and heard the opposite end of that, which was when Karen was in the back seat, she was calling John's phone and trying to, see where he was. And when they arrived at 34 Fairview, she just threw the phone into the back seat of the car. It was still dialing, still ringing, whatever. And then his voicemail recorded a conversation of Gemma Cabe calling 911. And also, we hear her calling her sister, Nicole, inside the house. Very, very quietly, but we can hear her talking to someone else when she's already off of the 911 call. So it's just interesting that we now get this perspective. Jen McCabe said a lot of things in there that really do raise a red flag. Like he got out of the car. That right there. I think she saw him get out of the car. She was standing in front of the door all night, according to her. So how did she miss him getting out of the car and coming in the house? I don't know, but she definitely knows more than she's letting on. The next clip I wanted to share with you was this creator. I randomly found her. I shouldn't have, let's see.
This is a 3D illustration on the
Oops.
No, please, it's court line. What is your emergency?
Yes, I need someone.
Okay. This thing is not working for me. This is the last clip I have for you. This is Asget Industries, spelled Azget Industries, and this is her YouTube channel, and she has an interesting take on the key cycles. So here, let's look at her video.
This is a 3D illustration on the subject of key cycles, which is a very important piece of evidence that is widely overlooked. The data in this key cycle is referring to everything that creates.
Remember, the key cycles are what Trooper Paul used in order to say there was some kind of triggering event. That's the one, he said this is the particular event that was when she hit John. So using the correct key cycle is very important here.
This scene by Trooper Paul, and if he's wrong about the key cycle, it destroys his complete case. So let's start with the basics. This is a simple ignition switch. When you turn the key fully, you'll hear the engine start. After hearing it start, you'll release the key and it falls back to its on position. Then of course, if you turn it back fully, it turns the car off. Now you can stick the key in and turn it simply to the on position. This is a key cycle. Then when you start the vehicle, this is an ignition cycle. All these cycles are recorded in logs. Every single time since the birth of the vehicle, every key cycle is recorded and logged. Even when you fully start the vehicle, creating an ignition cycle, there will always be a key cycle logged. So when Alan Jackson asked Trooper Paul if every ignition cycle has a key cycle, the answer should have been yes, but that would have hurt his case. So he was either deliberate in his deception, or at the very least, he lacks the expertise in the field to know better. Let's view that interaction.
That's for sure. He definitely lacks the expertise in this field. He's done a few hours of coursework versus the PhD experts of physics that we use in biomechanics that the defense brought in for their experts to explain the car accident or the reconstruction.
Every ignition cycle includes a key cycle, correct?
In a sense.
By definition, it has to, right?
It doesn't have to.
To clarify, regardless of the expert's opinion, every turn of the key is a key cycle that is recorded. So let's look at what key cycle numbers they're fighting so hard over. It's right here. Key cycle number 1162, out of Trooper Paul's report, which goes with the trigger report that has all the throttle, braking, steering, and speed information that was created in the scene. The problem is, when the key was put in creating key cycle 1162, it wasn't Karen putting in the key. Let me show you how we know this. Trooper Paul started the car, creating key cycle 1164 during his testing. Moving backwards in time, we know the next key cycle was when the SUV was drove off the tow truck and pulled into the police department's garage. This would be cycle 1163. When the police department took possession of Karen's car at her parents' home, they started the vehicle and drove it on the tow truck, creating cycle 1162. Continuing, earlier in the day, Karen and her dad started the vehicle and drove it from John's home to his home, creating cycle 1161. And going back one more time, when Karen left John's home at 5:07 to drive to Jennifer McCabe's home, this would have been key cycle 1160. Now these are known key cycles. There can be many more that are unaccounted for, but the point of all this is that 1162 wasn't Karen. It simply doesn't match, no matter how they try to justify or equate things to be different than they really are. It's just nonsense. Key cycles are recorded for a reason, or the system in a Lexus wouldn't work correctly when collecting data. It's that simple. Thank you for watching.
Gosh darn it. I just realized I was muted and my dogs are making so much noise because I don't know why. So, yeah, they're muting. I'm sorry. Okay, let me back up. So, I wanted to bring this portion of you. I thought it was a funny. I always go to like Reddit or YouTube and look at uh, people's comments, what people are talking about, thinking about in this case. And so I grabbed um, this particular post from Reddit because I thought it was funny and I wanted to share it with you guys. So it's posted by, hold on one second. All right, sorry. I don't know. There's a whole bunch of ruckus going on at my house. It's very frustrating. I was trying to quiet myself and then I muted myself and now I'm annoyed and frustrated, but whatever. Okay, so regroup. All right, so this is just something that I wanted to share with you real quick, just to wrap up this episode. So I always like to find, what you guys are saying in YouTube, in the chats, in the commentary, comments, at Reddit. I like to see, where everybody else is kind of leaning in this case because I just find it interesting. I like to see what people say. So this is posted by Yuri B and I thought it was funny. So it's called I Want a Divorce. Okay, that's extreme. However, my husband and I do not see eye to eye. We've been together for almost 18 years and we have never disagreed on anything like this before. He is adamant she is guilty. I am not. We have argued more about this case over the last few weeks than we have anything else. I'm finding myself looking at him in a different light. We did make a deal that if the feds bring charges on anyone involved, he will concede. So that's good. Anyone else going through this? We really need a trial. We really need a trial we can agree on so I can like him again. Please, for the love of all that's holy, I need Sarah Boone's trial to happen, which that's coming. But anyways, so I thought that was funny. And then I thought the best response was this by Fish, I don't know, Pufferfish. Ask him to explain to you how to rectify the incompatibility between the laws of physics and the alleged crime. Ask him if there is a reasonable possibility Karen didn't hit John with her car. This would be reasonable doubt. Ask him to resolve all of the following. Number one, no pictures of car before being taken into police custody. Reasonable doubt. Number two, no clear video of the taillight while at the Sally port. Reasonable doubt. Number three, initial police at crime scene find no evidence. Number four, plow driver saw no bodies. Number five, the medical examiner refuses to say that the car hit John. Number six, Trooper Paul said that he did no science or math and made the facts fit his conclusion. Number seven, independent experts say crime is scientifically impossible. Number eight, Apple Health steps 3 flights of stairs. Number 9, Karen Reed's phone connecting to Wi-Fi at John's house prior to the alleged time of the crime. Number 10, solo cups collecting the blood samples. Number 11, countless butt dials and deleted calls and texts from the McAlberts. Number 12, Proctor's texts. Number 13, other cop saying taillight was only cracked. That was the Officer Barros said that. The Dayton Cup, saying that there was only a small hole and it was cracked. Number 14, the key cycles, which we just watched a video on. Number 15, the disappearance of the dog, selling of houses, discarding of phones, and breaking your SIM cards. Number 16, ME, the medical examiner saying the injuries are not typical of a vehicular pedestrian collision. Number 17, arm injuries and no bruises or other injuries below the neck. Number 18, location of body. Number 19, attempted hiding of Collins' presence at party. Number 20, inconsistent statements, no mention of I hit him in initial police reports. Number 21, grand jury testimony versus trial testimony. Number 22, new interview of the Alberts or no interview of the Alberts or search of their home when the body was found. Number 23, no chain of custody of evidence. Number 24, Ford SUV seen outside of the house in the middle of the night. That would be the Ford Edge. Remind him that the prosecution has the burden of proving guilt beyond a reasonable doubt. Remind him that it is irrelevant whether there was a conspiracy or a cover-up. Remind him it doesn't even matter if he thinks Karen Reed is more likely than not to have committed the crime. All that matters is whether there is reasonable doubt. A low bar. That, my friends, is where I leave you. It's a great summation by Pufferfish on Reddit. What would you add to that list? That's what I want to ask you guys. Let me know in the comments below what you would add to the list as to what else is reasonable doubt. There's so much reasonable doubt. They only like skimmed the surface with this, but I thought it was a really, really good example. But I mean, there's the federal investigation. There's so many other things that you could just keep going on and on and on with this case as to why there is reasonable doubt. I wish the jurors could see this, but obviously they can't. What would you guys say is reasonable doubt? Another thing that was maybe overlooked in this list. What would you add to it? Let me know in the comments below. Thank you guys so much for watching. I look forward to hearing a not guilty verdict, hopefully Monday morning. I will see you guys later. Take care and bye now.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.